Hello, my name is Iain Larkins of Radius Law and welcome to our commercial bulletin in association with LexisNexis. The Economic Crime and Corporate Transparency Act of 2023, the ECCTA, introduces significant changes to Companies House. Some of the changes were implemented in 2024, but further changes are expected this year, including commencing from the autumn, there will be new identity verification requirements for new directors and PSCs. Identity verification for existing directors and PSCs will be required at the time of the relevant company's next confirmation statement. New financial penalties for non-compliance. Companies House will provide warnings first, but may subsequently issue fines for non-compliance. Financial penalties will range from £250 to £2,000. In addition, there may be daily penalties until the breach is corrected. Also expected this year is a requirement that all corporate entity directors must consist solely of natural persons. The Court of Appeal has ruled that directors that took preparatory steps to set up a competing business before resignation did not breach their fiduciary duties. In this case, the directors' actions were deemed preparatory and not conflicting with their duties, as they resigned shortly after receiving approval to register their new company. This decision highlights that preparatory steps alone do not constitute a breach unless they involve a conflict of interest or actions against the company's best interests. In a significant ruling, the English Commercial Court has rejected the long-standing Shareholder Rule, which prevented companies from asserting privilege against their shareholders. The court found that it is outdated and no longer sustainable under modern legal principles. The ruling may be appealed given its departure from the long-standing precedent, but it aims to ensure companies can have candid discussions with their legal advisors. The Court of Appeal's recent judgment in Toppleson v Rolls-Royce examined set-off of counterclaims and interest provisions in relation to liability caps. Rolls-Royce's claim was nearly €8 million. However, the court accepted that Toppleson had a claim for €800,000 in unpaid fees. The contract had a liability clause which capped the total liability of either party to €5 million. Now, the High Court applied to set off the unpaid fees before the liability cap. In other words, it calculated the claim as €8 million less the unpaid fees of €800,000, so equaling €7.2 million, and then reduced this again to the €5 million to match the liability cap. But Toppleson appealed, arguing that the set-off for its unpaid fees should be applied after the liability cap. The court agreed with Toppleson. Rolls-Royce's claim was reduced to €5 million less the unpaid fees, so equaling €4.2 million. Additionally, the Court of Appeal found that interest for late payments was outside the cap, as including it would deny Rolls-Royce its remedy for late payments. The High Court has ruled that an energy supplier had not waived its right to terminate a contract despite continuing performance for 6 months after the right to termination first arose. The court ruled that a party can only waive a right if it has actual or blind eye knowledge of the right to terminate. Now, in this case, the court determined that the relevant individual had neither actual nor blind eye knowledge. The relevant clauses in the contract were complicated, and therefore the energy supplier was only deemed to have knowledge of the termination right after it had received legal advice. The Supreme Court's ruling in SkyKick v Sky has clarified that overly broad trademark registrations can be challenged for bad faith. The case began in 2016 when Sky sued SkyKick for trademark infringement. The Supreme Court found that some of Sky's trademarks were registered in bad faith due to the lack of intent to use them for specified goods and services. Now, that said, the Court of Justice of the European Union, the CJEU, has clarified that a determination of bad faith does not invalidate the entire trademark. Instead, if contested, the applicant's trademark specification may be reduced to the goods and services that should have been originally applied for. The Court of Appeal has addressed terms in a lawyer's contract requiring a consumer client to pay full fees even if the hearing was cancelled. Now, under the Consumer Rights Act of 2015, the CRA, unfair terms that create a significant imbalance between the parties are unenforceable. Now, the lawyer argued that the terms were fair and in any event, core terms such as price are not subject to any fairness test under the CRA. The court ruled against the lawyer. Whilst a price clause is not subject to any fairness test, this clause was about whether the price was payable rather than the actual price. Further, as the clause placed all the financial risk on the consumer without acknowledging the barrister's ability to mitigate losses, the clause was unfair and therefore unenforceable. Data protection law obliges organisations that control personal data, data controllers, to manage any organisations that process data on their behalf, the data processors. A new opinion published by the European Data Protection Board, however, has stated that the data controllers' obligations extend to the entire supply chain, in other words, to all sub-processors. According to the opinion, data controllers' obligations include maintaining information on all processors and sub-processors, including identity and processing details, verifying that all sub-processors provide sufficient guarantees to implement the appropriate measures to protect the data subjects, verifying that data processing contracts are in place with the initial processor and the additional processors. The Information Commissioner's Office, the ICO, has published new guidance to encourage the sharing of data to tackle fraud, emphasising that data protection laws do not prevent responsible data sharing. To comply, organisations should conduct a data protection impact assessment, a DPIA, set up data sharing agreements to clarify responsibilities, identify a lawful basis for data sharing, and adhere to UK GDPR principles of fairness, transparency, purpose limitation, data minimisation, accuracy and security. It's worth noting that the Economic Crime and Corporate Transparency Act also introduces a new corporate offence of failure to prevent fraud, set to come into force from the 1st of September. So arguably data sharing to prevent fraud will then be an obligation. I'll now hand you over to our expert employment lawyer, Sandra Martins, who will take you through our key employment stories.
Most employment tribunal claims must be made within 3 months of the alleged mistreatment or dismissal. In November 2024, the government proposed a number of amendments to the Employment Rights Bill, including extending the time limit for bringing employment tribunal claims from 3 to 6 months. Employers who propose to dismiss as redundant 20 or more employees at one establishment within a period of 90 days or less must comply with collective consultation obligations. If employers fail to comply, tribunals may order them to pay a protective award of up to 90 days' pay to each employee affected by the proposal. A proposal to dismiss and re-engage 20 or more employees on new terms, or fire and rehire, will trigger the collective consultation obligations. From 20th of January 2025, tribunals will have the power to increase protective awards by up to 25% if the employer fails to comply with the Code of Practice on dismissal and re-engagement. From April 2025, the following rates will apply: £187.18 a week for maternity, paternity, adoption, shared parental and parental bereavement pay and maternity allowance; £118.75 per week for statutory sick pay. National minimum wage will be £12.21 for workers aged 21 and over, £10 for 18 to 20-year-olds, and £7.55 for 16 to 17-year-olds and apprentices. the EHRC has published a checklist and action plan for employers to help them comply with the duty to make reasonable steps to prevent sexual harassment of workers in the course of employment. The checklist was originally designed for the hospitality sector, but it can be adapted to suit different workplaces. ECAS have published new guidance on gender reassignment discrimination in the workplace, which confirms that the protected characteristic of gender reassignment may include non-binary and intersex people, and outlines steps that employers can take to prevent discrimination. Ms. Carosi is Brazilian and was employed as Marketing Engagement and Partnerships Manager at Hertfordshire University. Her manager told her that a strong accent was difficult to understand. Ms. Carosi resigned and claimed that the manager's comments amounted to harassment related to race, and the employer's refusal to share notes of a meeting because they might be used against them in an employment tribunal proceeding amounted to victimization. The tribunal dismissed the claims because the comments about the accent were not motivated by race, and the employer would have withheld the meeting notes from any employee who intended to bring any type of claim. On appeal, the Employment Appeal Tribunal, EAT, held that harassment may occur when the harasser is not motivated by the protected characteristic. Comments about an accent may be related to the protected characteristic of race, and if they are unwanted and reasonably have the purpose or effect of violating dignity, they can amount to harassment. And the tribunal should have asked whether the refusal to supply the notes was to a material degree influenced by the fact that a discrimination claim had been made. Employers should carefully handle performance issues that may be related to a protected characteristic and ensure that meeting notes are accurate, as they may be disclosable if the employee brings a claim. That's it for this month. Thank you for tuning in. We have included links to all of the documents we referred to today in the written version of this bulletin. But please don't hesitate to reach out to me or any of my colleagues here at Radius Law for more information.